They were very clear. But there's something I read in there that was fascinating. They said, for example, that as far as the tradition is concerned, the hearing of cases during the legal vacation is almost up to the lawyers to decide. And once a lawyer indicates that they are not available, the judge is obliged to simply postpone the case, adjourn it till the legal vacation is over. And that has been challenged by the Deputy Attorney General, who says, if that's your position, then you're fundamentally saying that the conduct of cases before the court is now at the behest of lawyers and not the court or the trial judge himself. That is a fascinating position for the GBU to take, but the rebuttal from the Deputy Attorney General also raises very interesting arguments that we will now look at. Yeah, we are talking about these high-profile cases, but it could have implications also for others. And so let's look at it more broadly in the context of the delivery of justice as we look at the issues one wants to say for a conversation. Just in the last couple of hours, the New Patriotic Party has also issued a statement, and they echo the point made by the Ghana Bar Association. And their point is very clear, that this is all part of a scheme to persecute NPP former appointees, those who belong to the former administration, and that the Chief Justice is part of that. In fact, they warn in that document that they issued tonight that the Chief Justice will be held accountable, and that even if he retires, it doesn't immune him from accountability. Strong words from the MPP tonight. We'll look at that too when we sit for a conversation. So what really is the big deal here? My guests will weigh in. Does this go to rights? Does this go to the administration of justice? Let my guests give us some insights into this when we sit after this.
That's right. Did you see that? That is me. Without me, that tap would just be decoration.
That's so. So when the water comes, where exactly is it waiting? Pipe. I also didn't see any bedroom no. Me tank. Me na me kura.
At least I move water.
And I keep it safe.
Without me, nothing flows.
What's happening?
I bring the life.
I preserve it.
Hey, why is the water going on and off like this? Maybe I can do it alone.
Maybe I need you too.
Strong, reliable, built for every home.
Syntex pipes and tanks. The perfect
water team. Syntex. Are you strong? Are you tough?
Can tee up someone in red. And it goes to
What's 5 champions league? You want to know? I be the real goat.
Who is the goat? Ghana Jollof or Nigerian Jollof?
Ghana Jollof has no co-equal. The smell alone. Oh my God.
No, that shift. You two they lie. Now the same stew when they use cook the rice and then they go put them for top.
You are lying. Ghana Jollof.
I knew this year. Forget everybody. Yeah.
My guy.
Put some respect on the goat.
On the goat. The only goat I know lives in Tama.
Every year we dey give to you back to back.
We are talking about PET. I want some Yaji face.
Except be the goat, huh?
My guy, him be the goat.
Though our choice of goats may differ in football, music, and jollof, Alomobitus always brings us together. Alomo, experience greatness in every moment.
Drink responsibly. Not for sale to persons under 18 and recommended to pregnant women. This advert is FDA approved.
Palladium Residences in Achimota isn't just an address. It's the home you truly earned. Secure your place with just a 10% deposit and choose from beautifully designed modern apartments or spacious townhouses built for everyday comfort. The this is more than a building. It's a vibrant, curated community with a clubhouse, state-of-the-art gym, and an on-site hotel, all at ABC Junction, minutes from Achimota Mall. Enjoy city energy while retreating to your private sanctuary. Call now to reserve your unit and benefit from limited launch incentives, including priority unit selection, executive pricing, and flexible payment options available. Don't miss the chance to pick the best homes. Book your private site visit today. Call 050-9823-424. Palladium Residences. Live smart, invest better. Upgrade your print game with Konica Minolta, proudly powered by SkySat Technologies. From all-in-one machines that print, scan, and copy to professional systems and heavy-duty production machines, we deliver unmatched performance. Right now, SkySat has an unbeatable offer. 1 entire year of free servicing on all Konica Minolta machines. That's 12 months of expert maintenance for new and existing customers. Visit our new VIP print center at Pegasus Place, Airport Residential Area for a live demonstration. Call us on 050-164-5180 or 0302-798-829. Again, it's 050-164-5180 or 0302-798-829. SkySat Technologies. Performance that delivers every time.
Tee up someone in red, and it goes to
That's who goal is for. I got 5 Champions League. You want to know? I be the real goal.
Who is the goat? Ghana Jollof or Nigeria Jollof?
Ghana Jollof has no co-equal. The smell alone. Oh my God.
No, that shift. You two they lie. Now the same stew when they use cook the rice and then they go put them for top.
Hey, you are lying. Ghana Jollof.
Are you busy? Forget everybody. Yeah.
My guy.
Put some respect on the goat.
On the goat. The only goat I know lives in Tama.
Every year we dey give to you back.
We are talking about PET. I want to hear the face.
Except be the goat, huh?
My guy, him be the goat.
Though our choice of goats may differ in football, music, and jollof, Alomobitus always brings us together. Alomo, experience greatness in every moment.
Drink responsibly. Not for sale to persons under 18 and recommended to pregnant women. This advert is FDA approved.
Why? What's wrong?
Paper jam.
Introducing Ghana's leading pay-as-you-copy photocopier leasing company. Lease an A4, A3, heavy-duty or production machine and pay for only the copies made or design your own payment plan. Simple and tietia. That's not all. Incredibly, toners, repairs, maintenance, follow-me printing, centralized tracking all come free of charge. Remember, financial prudence is the name of the game. Folks, forget about the expensive gimmicks and be smart. Join the hundreds of satisfied clients across all the 16 regions and every sector of the economy and save over 60% of your printing costs. Visit us at www.valixlease.com or call 0244-644048. Be prudent and lease a copier. Terms and conditions apply. Valix Lease is a wholly owned Ghanaian company. Valix Lease, affordable document management solutions.
And thank you all for staying with us here on PMX, which is always brought to you by Syntex Tanks. It is strong. It is tough. Also brought to you by Pepsi and Cavity Fighter Toothpaste, and also brought to you always by Stanbic CIB Impact Series. And by the way, this has been a very interesting day as far as the judiciary is concerned. And those of us mere mortals watching on have many questions, and I believe you do too. And let's put them to those who understand this space better than all of us. And Kwekwan Sasare will join us pretty shortly. He is a former director of legal education in Ghana School of Law. He is one of those who has practiced this profession for almost more than 3 decades. So I'm looking forward to picking his thoughts on this controversy that has erupted over the cases before the judges. We call them vacation judges. We'll learn more about that pretty shortly. Today, the Ghana Bar Association issued a statement, rather they wrote to the Chief Justice, complaining but also referencing the 3 petitions that have been sent to the Chief Justice on this particular matter. And we have in the studio Roxy Nelson Afiamepo, who is the national president of the Ghana Law Society. He's also the majority chief whip, and I'm delighted that he can join us. Samuel Atachia will also join us. He is the lawyer for Kabna Duboahin, who will join us pretty shortly. Noah Odamte Tete is the president of the Young Lawyers Forum of the Ghana Bar Association, also joins us in the studio. And thank you, gentlemen, for your time on the program. And I want to...
Yeah. Congratulations.
This is a position you
yes, I held for 7 years. There was, and Samson was my vice.
The vice, I remember.
And we...
You guys caused a lot of trouble. I remember, you guys, the two of you yourself, it's caused a lot of trouble. I remember very well covering the trouble you caused. But yes, he is the president of the Young Lawyers Forum of the Ghana Bar Association. Thank you, gentlemen. And I want to go to Atachia first. Mr. Atachia, thank you very much for joining us. You were not in court today when your client's case was called. Why? Do I have Atachia on? Hi, Mr. Atachia,
yes.
Can you hear me? Yes, great.
Yeah.
Great to have you.
Can you hear me now?
Loud and clear, yes.
Okay. Yes, I didn't see myself lending my energies and also my thinking and my being to what I see as an aberration. Because we have a tradition of the bar, we have the Courts Act, and we have CI 47 talking about legal vacation. My dear brother, just look at the linguistic evidence in the law. It's called legal vacation. It's not an ambulance trial. It's got nothing to do with anybody's pleasure. So you have the Supreme Court on vacation. The CJ himself is on vacation. Is that not so? But in the wisdom of the CJ, some judges should sit as vacation judges to deal with emergency situations only, which is by way of a motion. And even the motions are done now by virtual technology. You don't need to come to the court in the comfort of your conference room. You put on your tie, everything, and you start the motion, and that's it. So I'll ask this question. Why should the Chief Justice give a warrant to judges who have heard part cases of some special cases and say that those special cases, they should go for trial? So part heard cases should continue. And these are without the reference to the programs of the lawyers, whether the lawyers will go abroad to do some good medication, or the lawyers who go to International Bar Conference, or the lawyers who travel, whatever. So I keep asking this question. What selective justice is the Chief Justice trying to foist on us? All the murder cases, all the manslaughter cases, all the rape cases, and other criminal cases that are part heard, they are not of consequence at all. The Chief Justice doesn't care about that he wants to bring a warrant that those cases should be given expedited hearing. But these 2 cases, which a lot of people are talking about, how it is so important to somebody somewhere, should be put together, and then the judge should continue. So I believe that I've come far. I'm not a little boy in the game for me to use one case to cancel the traditions, the practices, and the statutory provisions of Ghana.
But what about the junior lawyers in your chamber? Can they represent you in this case?
Well, the case is not for junior lawyers to handle. If you see what is going on in the realm, So I need to be there. Because the one who hired me needs my experience and gravitas. To come to terms with a case that since Gordgesberg's time of the Gold Coast, national security matter has never been a subject matter of an open trial. I think it's a small case that we are doing. A dangerous precedent that because of one man, let's cancel the whole of the submarine tactics of national security and put national security on trial. I don't think a junior, will be able to face such an unprecedented, case coming from the Attorney General. So I couldn't cede space to a junior to go and do this job for my client, with all respect.
But legal vacations are part of the architecture of the justice delivery system. And I notice you make the point that legal vacation and the vacation judges must only hear the motions, and as has been said today, interlocutory matters. But I notice also that when it's the case of the matter before a judge is a substantive matter that the judge is already hearing, that judge is allowed to hear those cases as well. But in that same case, that judge can also hear interlocutory matters from other judges on vacation. But when a matter is substantive before them, they can hear those cases.
That is the election of the judge. But it should be referable to the convenience of the lawyers. So therefore, if the judge on his own motion believes that a part-head case in a land matter should continue, but the lawyers have traveled to Singapore, how is he going to secure, their buy-in to continue? Let's get it clear. And the warrant is telling the judge that continue with these two cases. That probably is very consequential for the Attorney General. So that's the selective justice I'm talking about. So if you want a part-head case heard during vacation, it behoves the judge to get the buy-in of the lawyers, because if the lawyers are not present, how are they going to conduct the case? Because of what the law says, they should go on legal vacation. And let's get it very clear. This particular one is a special thing for somebody, because probably somebody wants special results.
Explain that, because I've heard you make the point today. It's just for somebody wants special results. What do you mean when you say that?
Well, somebody believes that, at the end of the day, MPP could not jail some individuals, no? The whole of the time of the MPP, they couldn't do 10, cases successfully. And this is our time, and we've not done 2 years. We've secured about maybe 5 or 10 convictions. And therefore, so long as I am in a hurry to get people convicted, I'll push the lawyers to come and work during the vacation. That's how I see it.
So this, as far as you're concerned, is part of a grand conspiracy to simply railroad your clients, get them fast-tracked convictions for the NDC to prove a point that the oral case, I believe, the oral agenda is moving along as was intended.
You cannot run away from this inference. Because what is the ambulance nature of this trial? What is special about this case? Why do we believe that, for whatever reason somebody is having, we should continue with these cases? And what about the other cases? They don't matter in the realm. Is that not so? Somebody has murdered another person. That's a part-head case. The judge who is doing the part-head trial is resting. So why Dubois' case? So these are some of the matters that we should question the Chief Justice's discretion to give a warrant to a judge that, look, no matter what it is, whether the lawyers are ready or not, let's foist these cases on them, and they should come and continue the trial.
If we take the suggestion of a conspiracy, then that suggests that the Chief Justice is part of the conspiracy in league with the NDC.
You are saying that, but is it not logical to you? What is the point of the matter? What is it that anybody is trying to achieve? Yes, if NDC would want to have convictions, it should go through the rule of law. And nobody should aid anybody to get somebody convicted. They should come to court and with the greatest of respect, let the system run and then prove beyond reasonable doubt. But you can't find anybody saying that, oh, this is the temperature of the executive. The judiciary should give aid to that so that people suffer, in a manner that even when the lawyers are on vacation, let's hold them because some people are in indecent haste to get some cases cleared off. I can't come to terms with that, I can't come to terms with that.
Earlier in your submission, you made the point that hearing of cases, substantive cases in a vacation court before a vacation judge, must be subject to the convenience of the lawyers. And I've seen that articulated in the Ghana Bar Association statement, the letter they wrote to the Chief Justice. But if we are to take that point, though, you're suggesting that the administration of justice and the conduct of a trial is somehow subject to a lawyer's dictate and not that of the judge or the court.
Far from that. I've brought to your attention a very foundational issue, the statutory provision of legal vacation. If they believe that we shouldn't rest, what was the sense of the Courts Act and by extension CI 47? So it is envisaged under the law that the lawyers and the judges should rest. What is the meaning of legal vacation? Is it semantics or is practical? And therefore, when a man wants to rest and a judge believes that there's a part-head case, a very prominent land in Pram, it's a subject matter of a trial and it's part-head, he should seek the buy-in of the lawyers. That, are you able to come so we continue with the part-head case? Because we know that the bar and the judiciary, they are Siamese twins. If you separate them, it won't work. Administration of justice can't work. You need lawyers to appear before judges before cases are conducted. But how can you say that you want to run a case like an ambulance at the expense of who? So if the lawyers are arresting, it doesn't matter to you at all because somebody is an innocent is to secure political convictions or criminal convictions or whatever conviction they are interested in. I believe that justice should not be hurried because of some people's convenience politically. They prove beyond reasonable doubt hasn't gotten party colors at all. And one of the days we will all see that at the end of the day, all those people who want to set aside the force of the law to catch up with them in future.
Mr. Thatcher, please stay with me. Let's explore the points you've made a bit more with your other colleagues. Roxy, he makes a very fundamental point, and I've seen that the MPP has articulated it. He asks one simple question. Why is it that the hearing of the substantive case is restricted to these three high-profile political cases, which involves three members of the previous NPP administration?
Thank you very much. Let me say good evening to my big brother. I adore him a lot because it's very deep and erudite. And my brother, the new president of the Lawyers Forum, Young Lawyers Forum, as we used to call it. Yeah. Is this still the case?
Yeah.
Great. So you are welcome. Yeah. And our viewers. But my senior is wrong. And he knows that he's wrong. Look, I have data in respect of his office. Senior runs a chamber called Zoe Achia & Co. And he has about 17 lawyers listed as members of his law firm. And you see, let's place these matters in some context. What is the business of the GBA in this matter? The GBA has no business in this matter.
No, but the lawyers who have been affected are members of the association.
No. It's the lawyers. It's not the law firms. GBA is saying that they receive petitions from law firms law firms are not part of the Ghana Bar Association.
But the lawyers in the firm are.
Good. GBA didn't sit down. You see, GBA is an association of lawyers. And when we are lawyers, we are a community of reading men. And we deal with legalists. They didn't set the issues like that. They told everybody that they got petitions from law firms, not from lawyers. He's a member of Zoe Achia and Co. He's not a law firm. He is the one complaining. It's not a law firm that is complaining. So first of all, GB has no business in dealing with this matter because the law firms are not members of the Ghana Bar Association. The Ghana Bar Association is constituted by lawyers licensed by the GLC. The law firms, properly so-called, as we call them, chambers, they're also licensed separately by the GLC. So if you got a petition by some law firms, you ought to have written to them that there's a proper forum convenience for them to direct their petition. But I'll deal with the issues. Atachia has 17 lawyers in his law firm. And in my formative years, there were some of the lawyers that when I arrive in court early and I'm able to find my way and handle my motions quickly, I sit and listen to them. It needn't take how long it took because they were such lawyers. They taught us law in practice and we have imbibed and we are here. He knows that the case is presently litigating will fall flat. These matters have always come before the law court. So as far back as 2000, the year 2000, Justice Badu, in the matter of Boido and Tai, had cause to it was even a civil matter. He had cause to say that where a hearing notice is issued and served on a lawyer in the party, and the party gets to court and the lawyer writes to say that he has made vacation arrangements, the court is minded to proceed with the matter. Unless the court is minded to give the party opportunity to produce another lawyer to deal with his interest in the matter, or the lawyer gets back quickly to say that he is prepared to return to court at a more convenient date. And I'll tell you, he knows that during vacations, I made some of my names at the bar from vacation trials. What will my boss do? He knows my boss very well, Teprehudu Chasaibo. He would travel for like a month and maybe and a half. So he will write. Normally he will write to the court that I am not available to handle the trial. But out of courtesy for the court, because a hearing notice has been issued for me to appear during the vacation, I will send my genius. So let them hold my brief for a copy of adjournment. So sometime in September, he will come and then they will agree on a date. Because you see, at the bar, we extend courtesies to the court.
Yes, explain why he can't do that.
No, so let me tell you.
The sensitivity
and I'm also countering that with the number of lawyers he has under his watch. And he's such an excellent lawyer. He's been Jerry Rawlings' lawyer before. So he's such an immaculate lawyer. He knows that when you have genius under you, must give them opportunity to fly. And you use vacation cases sometimes to do that. So some of his junior partners could have gone to court to say that, our managing partner who is in control of this matter has maybe traveled for a couple of reasons. Those reasons will be stated. And therefore, he's pleading that he should be given a couple of weeks to return to take control of the matter. The court in vacation will grant you.
You're certain?
I'm certain because we've done it many, many times. Especially in October, if you pray that you want to return in September to come and deal with the matter, the court will grant you.
So you're saying, although the Chief Justice has said sit,
yes,
the discretion is left to the judge to decide.
It is always negotiation at the bar, between the bar and the bench, always.
So that if you don't appear before the judge, you will know.
Look, we were in this country 2023. Akufo-Addo was attending court every day. His lawyers at the time pleaded with the court that the everyday trial was most inconvenient. Why? Because they have other cases
But that wasn't during the vacation.
Good. No. So don't. But they did it also in the vacation. Now, what the court eventually agreed with them is that, okay, instead of the daily trials, we can let you come maybe 3 days in a week so that we can have 2 days in a week to deal with your other clients. The same approach was done in the Jachi Kwesin case. Jachi Kwesin was ordered, his lawyers were ordered to appear in court every day. In these circumstances, do you prefer a daily trial to a vacation trial? I would prefer a vacation trial to a daily trial. Because the daily trial, the tournament of trial, every day, sometimes you get home in the night, before Jack, it is 6 a.m., you must get ready for court at 8 a.m. So the daily trial is not funny. And no lawyer should say that the order to do a daily trial is better than the order for a vacation. So I am placing these matters in some context. I'm saying that Senior Tachia, bar politics, could have simply approached the registrar and the judge and negotiated that, for the month of August, it is fresh after July. I'm exhausted. I have some other arrangements with family and all that. So let me come back in September so that we do this. Nobody, no media would have heard about this. And it's something as lawyers we do always. Second.
But the petition.
Yes.
The CJ.
So I'm saying that. The petition is what triggered all these debates that me and you and him is on Zoom looking at me. He knows that step was wrong, erroneous.
Why is that step wrong?
It's erroneous because once a hearing notice in law has been issued and directed at your client, our duty under LI 2423 is to provide legal service around the clock, every day, every month, and around the year, especially when you are paid for the service. That is why lawyers often will bill by the hour.
So are you saying that the petition was to a wrong forum and that it should have gone to the judge?
It was first the wrong step to take, and it was also the wrong forum to direct the petition. Asking you using your chamber, because Atachia could have used his own personal letter, that he is the lawyer in the matter, he's the one complaining. So then you complain to your mother body, which is the GBA, to now raise the matter on your behalf. That would have been more appropriate. But using his law firm, which is not a member of the GBA, they are an entity, an incorporated entity. It's not a GBA member. And GBA assume responsibility to canvass the interest of the law firms. To that extent, it's an erroneous step. But I am saying that 26 years ago, this matter was determined by the Court of Appeal. Justice Badu said, no, where a judge makes his private arrangements to travel during the vacation, and the warrant of the Chief Justice says that a certain court should sit and hear a matter, you, the party, you appear in court at the peril, to the detriment of your case. Because if you don't bring your lawyer, then you must either fire a lawyer, look for a new lawyer, or you call your original lawyer and say that this is the position of the court, and therefore I am looking for a lawyer interim. Do you understand? For the lawyer to stand in for me until such time that you return after pro tem. So the lawyer pro tem can deal with the matter. But the point I'm making is that Atachia has so many lawyers who could have stood in pro tem for him and done a good job and acquit their managing partner in the matter. But he decides to go political. And look, if you look at especially his language directed at the CJ, he has been talking to me and coaching me about use of decorous language, both at the bar and in Parliament. Atachia has supplied me over 10 books to read. Some I have not even returned to him. He's such a good coach. So I am at pain to crisscross him in this matter. But I think that it is not too late. We can still engage the court and say that, look, all this brouhaha, all this saga, let us tone down. And please give us a time in September to come. Look, it's not even, the judge themselves are not happy. Because normally when they sit in vacation, when they sit as vacation judge, then they take their long vacation when court actually resumes in October. So normally they return around November. Because it's tedious for them to continue from January small vacation during Easter in April. They come back in early May. They work all the way to July, and then they are appointed to sit during vacation. It's tedious for them, but that is their call to duty. That is the oath that they swore to take. So vacation courses have been there before me. I was born, before I entered secondary school, before I became a lawyer yesterday. Atachi has been going to vacation court before I became a lawyer in 2009.
Let me ask him if he will appear before the court, and then we'll come and answer a very important question that will come up.
He needs to withdraw the petition.
I'll ask him that. I mean, Atachi, will you or any of your other colleagues in your chambers appear before the judge and make this request?
They will not. You see, first of all, my dear friend and colleague loses sight of the fact that it is not the judge that did a self-warrant. So if you say that my petition to CJ is wrong, he loses the point totally. You see, the judge was selected by the CJ to come and do a specific job. Therefore, if you want to question the warrant, then you shouldn't go to the judge. As a matter of fact, at the last sitting, the judge was very emphatic that, look, I'm a servant of the realm. If they want me to sit, I'll sit. But if you have any issues, deal with the CJ, who has given me the warrant to sit.
Was the warrant to sit as a vacation judge to hear all vacation cases, or to hear specifically the Dubuahin case?
To hear specifically a Dubuahin case and some other cases, which some of them are apartheid. This is very critical. You see, if the judge is sitting as a judge of the vacation, and all manner of criminal cases you look at, I won't say one word about it. But I'm saying that if the judge is sitting and they've ring-fenced some critical cases for him to expedite the hearing, I believe that that is selective justice and it undermines the Constitution, and I'll fight it. So I want to make that point clear. Listen to me carefully. If a man is playing semantics with this and he's talking about a law firm and lawyer, I said, oh, my dear brother and friend, it's the lawyers who are the animals who are to be working. I never said that my law firm is going to work, but it's me who's going to work. It is not because I'm tired. It's not because there is something of a personal nature which I'm fighting, but I'm fighting a tradition, a system that has been hallowed by the Courts Act and CI 47, that there's a legal vacation. It's not a personal convenience or personal comfort that I want to secure. I'm saying that if you say there's a legal vacation, then let them do the emergency cases and the motions. But I will not accept an arrangement which means that, oh, these are ring-fence cases for all the troubles of the realm. Let's look at these cases and deal with them, because that is a heartbeat of the Attorney General. I wouldn't lend my support to that. And we'll advise ourselves.
But while you do that, what about your client's interests here? You need to serve his interests. Today he was in court. He's been directed to come back on the 17th. If he doesn't come with you or come with another lawyer, he must do his own cross-examination. That is exposing him to great jeopardy.
Yes, that is coming from judges who have gotten their marching orders from the CJ that they should go ahead with the case. It's like the judge telling my client that, oh, if you have a toothache, go and find a carpenter, not a dentist. How can a judge seriously tell this gentleman that, look, where we are, the investigator is the one being cross-examined, but do your cross-examination yourself. I find it very weird, you know. I thought he would tell him that, look, go and find another lawyer if this man is not coming. But I am not worried about what the judge is saying at all. I'm challenging the foundational reasonableness and the decency of you saying that all the rest of the courts should go and rest. And that there are special cases that I want part head, and I'm stressing part head to continue. And counsel will agree with me that you can't get a part head case being adjudicated upon during vacation unless you get in the buy-in of the lawyers. Now, look, are you ready that we continue this land case? Would you be prepared for us to do the part head? But if you want to force a case on a lawyer to do during vacation, do you know the implication That's an arbitrariness of grave consequences.
Mr. Thatcher, again on your clients, I want to come back to that because I think the lawyers are having a good conversation, lawyers, judges, CJ. But at the heart of this is the liberty of your client. What does this position? You are fighting for what you believe to be something must be fought in principle. But what does this mean for your client?
My client will want the rule of law upheld. It is not this docket that constitutes the rule of law in the realm called Ghana. You understand? So my client really understands my position that, I'm fighting a cause that by extension will eventually inure to his benefit. So I don't see how my client is affected at all.
He agrees that you should take this course of action that may expose him to great jeopardy.
Of course, because he can't change the cause I'm fighting and the principle I'm trying to uphold. And I'm telling you, let's all be very, very sensitive to what we are trying to do, that it is not one brief, you understand, that should hallow the rule of law. One case. What about the generality of cases that we should just, consign to, time? The lawyers in those mass cases, murder cases, manslaughter, they don't matter to the realm. They don't matter to the Attorney General. Let's consign them to October. But let's handpick some few cases that is the heartbeat of the Attorney General and push them. What kind of selective justice is that? A two-track system in which one is in an ambulance mode and the other is the normal mode. You people can rest, but these ones, we want to find, we want to push it so hard and fast to get some results that we have envisaged. Please, this is inconsistent with the Constitution. And if anybody believes that this is what is normal, it's up to them.
You mentioned that you will fight this. You've sent a petition. The CJ today publicly rejected that petition. I'm pretty sure you've heard him. What's your reaction to what he has said today? That the lawyers cannot dictate how cases are heard, and that it's wrong to say that because there is a vacation judge sitting on the substantive matter, then that matter cannot be heard until, of course, the vacation is over. Well, what's your position?
No,
what's your reaction to it?
No, we are too humble to dictate to the Chief Justice. The Chief Justice should pay obeisance to the law and the traditions and the practices of our courts. I didn't insert the vacation, legal vacation in the Courts Act. It's not my invention. And it's neither his too. So the Chief Justice is the first person, the first gentleman who should pay regard to the law. So the vacation is not my invention. So I can't dictate how vacations are done. But I will question the discretion of the Chief Justice. And it's embedded in the Constitution. Article 23 is there. If you go to 296, it means discretionary power can be questioned and have a right to do so. So please, I won't fight the Chief Justice as a person, because he's a man that I respect. But I'll fight the cause that he's trying to, defend. If it's inconsistent with the Constitution, I'll do that.
Beyond the petition to him, what else are your options?
I will not let my sinners out now, but I work towards, bringing these matters to the logical conclusion. Because it is not my personal preference which will hold sway, but we are worshippers of the Constitution of Ghana. As Christians worship the Bible. That is what I want to do. It's not like, Adubuahin's case is so special to my a law firm. No, that'll be a very selfish posture. There are value systems associated with the profession that I want those value systems hallowed. And I'll take every reasonable steps to do that.
Thank you. I want to bring in Odamte. Odamte, there's a contest over two positions that I've heard the Ghana Bar Association express, and I've heard Matachan express too. That vacation courts only hear interlocutory matters, motions, emergency, applications, etc., but never trials. And I'm quoting the GBA here. Is that the case?
I find that position quite problematic, and I think that kind of position does not really adhere to, in my view, what we see with the practice of law that I have witnessed in my few years at the bar, and also with the law itself. First, I have heard that argument that when we think of what we do during vacation, we don't go into the substance of the matter. But that is never the case, because how do you even distinguish between what is the substance of the matter and what is not? Because I have been before vacation courts, and I am sure my seniors here might have seen similar instances where parties have filed motions that terminate the case. For example, when a party is filing a summary judgment, you can't term that as just a procedural or a motion that does not go to the substantive heart of the case. When someone files a motion on notice for judgment on admission, for instance, that is not a merely procedural matter. That brings the matter to a close. And so it is very problematic when we say the vacation courts do not go into the substance of the matter or do not go into trial. We must distinguish between two important issues here. One is whether the Chief Justice's warrant was ordering the courts to do specific things.
So he says that's not the case. That's the case.
No, so if
specifically trial the matter involving Edubwaheng and others.
Yeah, so that is the point I'm actually driving at. The Chief Justice asks the judge in hearing those cases to do specific acts. Because that would then be the Chief Justice taking away the individual or independence in the exercise of judicial power by judges. That is not what I see the Chief Justice do here. Chief Justice has the power under our law to specifically state that certain cases must be heard. We should not lose track of that. I have seen my senior quote the Court Act and then the Civil Procedure Rules, for instance. When you read the Civil Procedure Rules, in my view, does not even apply here. When you read the Civil Procedure Rules, it tells you that the Chief Justice may decide, on even during vacation, for courts to sit on specific cases. So the Chief Justice has issued a warrant directed at these judges to hear these specific cases. It does not breach any law, right? The Chief Justice has exercised a discretion, and these judges are complying with that.
Yeah, but how did you explain the point he made that before the court today, when the application was made, agenda, so we returned from the legal vacation, the judge's point is, take this up with the Chief Justice. As far as I'm concerned, this case must be heard.
Yes, because the judge is acting at the warrant of the Chief Justice. Remember, the Chief Justice is the administrative head of the judiciary. And the Chief Justice has the power to earmark certain courts to hear specific cases, but even during the vacation.
But the judge can then, in carrying out that warrant, in the specific trial itself, can decide whether to grant a lawyer's plea for an adjournment or not. But in this case, I want to hear from Atacha, even that when the plea was made, she says, take it up with the Chief Justice. That almost takes out
I beg to differ on that, because I have been following a number of these cases. And I remember the last time they were in court when the judge made that statement, right? The judge's position is simply that he has been, per the warrant, he has been instructed as one of the courts to sit during the vacation. And he's going to do that. If anyone disagrees with that, they have to pick it up with the Chief Justice. It does not mean the judge is saying if the parties appear with their lawyers and they are able to clearly indicate that for some genuine reason they cannot appear, that judge is not going to, or there is no room for that judge to say, I am not going to grant it. There is a clear distinction between the two. But that brings me to a point that I think we also need to make clearly. I disagree with the position that my senior also takes in how he responds to the hearing notice of the court to appear on a certain day. He mentioned Article 23, Article 296, which allows him to challenge the decision of the Chief Justice. Of course, when the Chief Justice exercises a discretion, we are allowed to challenge it if we think that discretion is exercised capriciously or arbitrarily. But there is a procedure to challenge that. The procedure to challenge that is not for the lawyers in the matter to say we will not attend court. The procedure to address that is for the lawyers to respect the authority of the court that issued the hearing notice, appear before that court, and say that we disagree with what the Chief Justice has done by selecting these cases to be heard. And so we are filing our process to challenge the discretion of the Chief Justice. And I think that we as young lawyers, and me as a young lawyer, looking at a senior lawyer, I would have expected that we stick to the rules, we stick to the principles of the game, and ensure that the right thing is done to challenge the discretion of the court. Because does it mean that as a young lawyer, for instance, in the next time that a court fixes a day during the vacation that I think I don't want to attend, I can simply also say that I am not attending? I don't think that is the culture that, as a young lawyer, I believe that it should be inculcated at the bar. And so I think in this situation...
So you're saying that he must follow due process?
Follow due process.
Challenging the exercise of the discretion?
Yes. The Chief Justice believes he has exercised discretion within the remit of the Constitution and his power. Anyone who disagrees with that exercise of discretion, in my view, should challenge it using the right powers. Especially for a court.
Which is what exactly? Was a spelled out process there?
Yeah, so the Constitution allows us to challenge the discretion when it's exercised capriciously by filing a case with the Supreme Court. Right, to challenge that, because that discretion would then be unconstitutional. But with the court that has issued a hearing notice, or that has given a date for the lawyers and their parties to appear in court, I believe that it does not speak well to that court for a lawyer or the lawyer's client to say that we are not coming to court because we disagree with the Chief Justice. Because the court could have given an order today that will bind the parties. And like you've been rightly questioning, there are parties in the case beyond the lawyers. The court could have given an order that bind the party. The court was in its right to say that the party should go ahead and do the cross-examination. We would have spoken about that it was unfair in this situation, but we would have left out the fact that the lawyers on record should have been in court to raise this issue with the judge. So that is the issue that I find with the position that my senior has taken. And I believe strongly that the Chief Justice is within his power per the rules and then the law that has been cited in this matter. And anyone who disagrees with it must use the proper approach.
But they raise a fundamental point, and I'll come to Roxing also on that, which is, why are these cases special? And he raises the point, but the MPP in this also makes the point. Quote, the Chief Justice has failed to answer one simple question. Why only these two courts, and why only these cases? It comes back to the selective justice question that they're raising. They have a point, don't they? Once you select these cases and then give this instruction to a judge to hear them in the manner in which it is being heard, that's a textbook definition of being selective.
So I honestly don't think there is any real difference. You see, we need to understand that this is not the first time that certain specific cases have been granted an expedited pathway through our judicial process. Right. My learned senior here has mentioned the case of Judge Ikwesin, where he was coming to court every single day. What was so special about the Judge Ikwesin case? For Judge Ikwesin to be going to court every single day.
I guess as MPP suggesting, because it was political. It's a high-profile political case.
Exactly. So I believe that we need to come to you see, I don't want us to create a republic where we run away from the truth. We need to come to the conclusion that there are certain cases, by reason of the kind of nerve it touches with the republic, there is a need to try them expeditiously. We need to come to that. For example, the Supreme Court is on vacation. Are we saying that if there is a real emergent issue that requires the Supreme Court's attention today, dealing with maybe the presidency or parliament,
but this
Supreme Court would not...
point that these cases don't qualify. They are not in that bracket.
See, and the law has accorded the discretion to decide which cases should be given this kind of treatment to someone, the Chief Justice. Right, so the Chief Justice may have sat down and said that, look, these are cases that are very important to the Republic because, one, the public is really interested in how this case of corruption within our politics actually goes on within the court. The Chief Justice may have sat down and realized that over the years we have received complaints that these cases involving corruption in the political sphere take a long time within our judicial process. We need to address those issues. So maybe these two cases, which are before the courts, and remember, the Chief Justice has not just done this thing for the first time. Remember, we have specialized courts hearing these cases. Why did the judiciary decide to create specialized courts to address these specific issues? It means that they are not just ordinary cases going through the judicial process. So the Chief Justice, in his wisdom and within the powers available to him, then said that let's earmark certain courts as specialized courts to deal with these cases. Then these cases, because of how important they are, we need to attach some form of agency to them. So within the vacation, the courts should also sit to conclude these cases. I would ask anybody who is speaking against what the Chief Justice has requested that if the parties in this case were not on bail, would the lawyers in this case have genuinely said that they would rather that their clients stay on remand for 2 months and nothing be done, simply because there is a certain culture that they are pushing?
But that question also, if you flip it, strengthens their case. That because they are not behind bars and they are not on remand, it takes away the agency. Because then liberties will be at stake, and of course, and you know how in jurisprudence that's the
point I'm actually making.
Why do you then make this?
The agency and the reason this case is special is rightly because this case are not the ordinary case that the ordinary Ghanaian is involved in.
Okay. Look at that. Just a second. Atacha wants to make a point. I'll come to. Yes, Mr. Atacha, make your point. I'll come to your friend, Roxy.
Yes. No. I mean, now I'm hearing for the first time that when somebody files a summary judgment application, it tantamount to a trial. I mean, I've not heard it before.
No one has said that, Senior.
You said so.
No, I didn't say
that. The summary judgment application deals with the matter substantially.
I said that. I had heard that the argument has been made that during legal vacation we don't go into the substance of the case.
Trials, not
right. So my point was not about the trial. My point was about the substance of the case. But there is no law in this jurisdiction, Senior.
But what they say, I see it in the Bar Association, is trials.
Yeah,
they say never trials.
But you
see, all
interlocutory. We need to make the point, and I think I've made that point in my earlier comment, that there is no law, and I want my senior to possibly point me to that if I am wrong. There is no law in this jurisdiction that says that what goes on during the legal vacation, trials are insulated.
No, but there's also practice, tradition, conventions that, as you know, sometimes also can carry the effect of a law.
Yeah, but
that's how it's been practiced.
These practices are there, and they are subject to the authority granted to the Chief Justice. The Chief Justice is allowed, per the laws that my senior is quoting, to, on his discretion, decide whether courts will sit during the vacation based on the circumstances that the Chief Justice...
Just a second, let me hear him and I'll come to Roxy. Yes, Mr. Thatcher, make your substantive point, yes.
Yes, my substantive point is that there are other important cases. That's what he said. I want to take it up from there. What are the other important cases? What are they? The murder of somebody doesn't matter. Is that not so? Manslaughter does not matter. So the judges that are doing manslaughter and rape should go to bed together with the lawyers who are trying to help, the accused persons. But this is your so-called sense of important cases. What is the importance about it? Tell me. What is the importance about this criminal case? So why are we in an ambulance mood to distinguish between important cases and non-important cases? For the Chief Justice to say that I'm exercising my discretion relative to the important cases, but when it comes to the other cases, they are not important to me. This is the selective justice that we have to question the discretion of the Chief Justice to do so. But my dear brother, let me be very, very clear with you that, you see, you can't tell me that when the Chief Justice has given the warrant and the judge informs, the lawyers and the accused persons in an open court, that please, this warrant is not coming from me. The warrant says I should go on to try this case. So if you have an issue, deal with the Chief Justice. The judge said so. You were not in court. It was not a matter of hearing notice. It was the judge who said so, that the CJ has given me a warrant to try these cases. So where do we go? We have to petition the judge. So how can you fault us for petitioning the CJ who gave the warrant to the judge? But I respect a lot of things that are going on, but I could tell you from my experience that I will not respect any arrangement in which some cases are special and others are not. That arrangement violates the Constitution, and I'll defend the Constitution with every breath that I have.
But by using due process, Odamte's point is that there is a clearly laid out procedure for challenging the capricious exercise of discretion.
I'm more educated. I'm going to use due process.
Okay.
Is it not right to, first of all, inform a Chief Justice in the petition that, look, Mr. Chief Justice, I hold the view that your discretion has been wrongfully exercised. As to start and kickstart the so-called due process is talking about. Don't I know that I can go to the Supreme Court for declaratory relief? I know what to do. So I'm not going to put my arsenals out there but I know what to do.
So you're going to the Supreme Court?
I'll do everything to ensure that we don't have this aberration as part of our rule of law arrangement. And what is very, very, very funny about this is that do not ever say that Chief Justices can go wrong. Please, 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 please. If not, then we won't have Article 23.
I don't think I said that.
No, I think he's
making... He was right in what he did. That's what you said.
Yeah, but that doesn't mean he can't go wrong. So
Yes. So if he's exercising discretion, then the Constitution enjoins us to challenge discretion. So the Chief Justice hasn't gotten an arrangement in which everything he does is sacrosanct. If he goes against the Constitution, we can challenge his discretion. So we know what to do.
Okay.
But I'm saying that I have not disrespected Justice Achibonga by not appearing, because when I petitioned the CJ, I copied him. I kept him in the loop. Now, I will not be able to come to the court because I want the Chief Justice to reverse his warrant. And if the Chief Justice does not want to reverse the warrant, I know what to do.
Okay.
And nobody can say that by hook or crook. I mean, they should haul me before the judge to go and continue a case whilst we are in vacation. But the others will not be hauled before the judge to look at the other cases they are doing. It's unfortunate.
Roxing, there's a line I want to read to you from the GBA's letter to the CJ. It is in respect of this time-honored tradition that we write, as any attempt to do otherwise, with or without a warrant, will smack of bias or selective justice.
Okay. Now, the GBA has been in existence before I was born. In 2000, the year 2000, I insist, Justice Badu made a pronunciation on this matter and said the law, at least it's not been appealed against, that a lawyer cannot tell a court that he's on a vacation, therefore a matter for which a hearing notice has been issued and served on him and the party be deferred. The court may proceed. That's the law. So GBA is not quoting law. They are quoting emotions. And let me tell you, there are about 458 courts in this country. 458. 332 of these courts are magistrate courts and circuit courts. They work 24 hours. They work around the clock, and they work 365 days in a year. The judges in these courts only get to go on vacation as arranged with the judicial service. They don't have a vacation declared for them in a year. They are part of the judicial service. The only number of courts that get to go on a vacation are 136 courts, made up of the Supreme Court, which is 1, 6 courts of appeals established in the various regional zones, and 129 high courts. These are the number of courts that fall within what we call the superior courts, and therefore are privileged to fall under the Order 79 rule in the CI 47. Now, CI 47 is the rules that govern the civil procedural matters in our superior courts. Act 30 govern the criminal procedural matters in our courts, including the high courts. So the appropriate procedural laws to quote in this matter is actually Act 30. Act 30 says that every court says with a criminal matter can proceed with it. In fact, we've been told, and I know he will agree with me, that a court is where the judge says it is. A court is where the judge says it is. Do you know courts can be held under trees? When the judge says, for some circumstances, let's sit under a tree and hold a court. When a judge is holding court, that is where the court is. And Senior Tachi are the people who taught me this. And let me tell you this today. Trial in civil matters governed by CI 47 is strictly by procedural rules. So if you go to Order 32 of our CI 47, it tells you what you must do at what we call the direction stage, like pre-trial. So you take directions and the court will determine how the matter will proceed. It is known. In the criminal matter, you are on trial as soon as your plea is taken. So, but for the exigencies and the burdensome nature of the number of cases before the court, when your plea is taken, evidence must be led as soon as possible. So, trial, qua trial in respect of criminal matter is markedly different from trial, qua trial in respect of criminal matter, civil matter. Because civil matter, you are governed by either, if you are before the district court, CI 59 has variously amended, and if you are before the superior courts, governed also by civil trials before the circuit court, CI 47, variously amended. So you can actually not be quoting provisions in CI 47, which is for the civil modalities of conducting a matter and making argument to govern a criminal, because criminal matter, somebody's life and liberties is at stake. If the person is not careful, it's the entire republic that is coming after the person or against the person. So there's the inherent principle in trying a criminal matter is expeditious hearing. That you must ensure that the hearing is conducted quickly, so much that the person will have his freedom if he's not guilty. Look,
Atacha makes the point. There are many criminal cases, there are murder cases.
So let me ask him.
Isolated.
So let me ask him. When he was in government, he was a principal member of the government. Akufo-Addo could go to court and trial the current finance minister on day-to-day basis, and leave Gregory Akufo, who had been granted bail. He will lead the republic. They will oppose bail, go to court of appeal, and have it reversed. Gregory Akufo remain in jail. He is not bothered. But you'll be trying, you put Akufo-Addo and co on trial every day. What makes a prosecutor makes those determinations? It is discretion. When they had the power, they abused it. Look, in 2023, CJ Tokonu declared 12 courts as vacation courts in this country. Akufo-Addo was the Attorney General. Senior Tachian was a member of Parliament. I believe at that time he was still chairman of the Finance Committee or Energy Committee.
Energy Committee.
Did he wince? Did he cry? Me, some of my biggest cases were done in the vacation. And let me again say this. Look, Atachian said he had to write to the CJ to complain. Nobody is saying that his complaint petition to CJ was not founded. We are saying that their decision to write to their association, for the association to lead their crying, is what some of us have a problem with. They didn't petition the association as lawyers. They petitioned it as a chamber. And I'm saying that the chambers have no business petitioning the GB.
He's addressed that. He said that's semantics.
Yes. And let me say, Okujeto, and we are told that Okujeto also petitioned.
Yes.
Some Okujeto and associates, they have on record 31 lawyers. From him as the senior partner, the daughter as deputy managing partner, Victoria Bat as managing partner, all the way to the partners and senior associates and all that. They are 31 in one law firm. How can this law firm not find it fit to appoint some lawyers to work on his behalf during vacation? So it is not fair even to the Republic for a law firm such as this to claim that they can't work during vacation. Because law firms don't go to sleep. Law firms work around. Every day they are receiving clients. And they are taking on new cases. That is work. That is legal service. And legal service, as defined, is not only co-terminus to trial in the law courts. Legal service includes sitting in chamber doing solicitor work and offering opinions. Again, I've mentioned Atachian. If we take Akufo-Addo, Dami and partners, at least from what I gathered from the internet, there are 4 lawyers listed. 4 lawyers manning a law firm as Dami and partners. They are too many to handle any case during the vacation. Look, Evans, they have no case And some of us are so scandalized by the GPA president entering the fray and writing such scandalous language and directing it at the CJ. Because the GBA president knows that is not her forte. That is not her strength to communicate. Because they know that in these matters, when a hearing notice is issued from a court of law, every lawyer is ethically bound to observe. So even if you are incapable, let the court hear you.
But even heard. Atachian says
No.
they make the plea.
No.
The judge refers them to CJ, and that is why they follow up
but
with
that's
the
not
CJ.
the end. You go back and say, my lord, this matter, I don't even want to go to the CJ. I want to engage you. That give me 30 days to rest. So that in September, look, I am telling you.
They've already told.
No, they have decided to play politics with this matter.
No, the
Do you
judge
remember?
has said clearly.
Let me tell you
The
this.
warrant says I should
Let me
hear
tell
this
you
case
this.
and I will hear it.
In the trial, the Republic versus Chachu Chikata, we were there in law school. Remember that he went to court one day.
Yeah.
During court vacation like this, and his lawyer
was away.
Professor, may I call you?
Yeah, and I was in court that day.
Yes.
And he represented himself.
No, he was directed by the court.
Yeah,
let's recount this properly.
And then he came with the Bible.
He intimated to the court that, Professor Ovio Dankwa, thank you.
Yeah.
Professor Ovio Dankwa had traveled, and Professor Dr. The Haveman,
and that was during the vacation.
During vacation. The judge said, no. Mr. Chikata, you better find another lawyer or to do the cross-examination, or you are a lawyer yourself, so you are capable. He was compelled. Under strenuous circumstances, he wasn't even well. In the quality grain case, Justice Afre compelled the parties that if their lawyers wouldn't appear in court, then he was going to instruct them to.
But if it was wrong,
hold on, no,
it's wrong.
Nobody said it was wrong.
When it happened.
All we said was that, we could have been given another time, like maybe a week or two.
To appear. I was in court. The view then from the Free Chachu movement at the time was that this was all part of the conspiracy to jail.
So they didn't say that vacation hearing was wrong. They said that once a party, in fact, an accused person especially says that my lawyer is unwell, he's taking leave to deal with some medical condition, and therefore grant me an adjournment. Chachu was asking for adjournment. He wasn't saying that vacation sitting of a court was wrong.
Yeah.
The court won't hear him.
Yeah, the court did not.
They compelled him to conduct his own cross-examination. Atachian was in government then. He was a senior member of the government. Godfrey-Addo was then a young lawyer, and he was practicing in Akufo-Addo. Akufo-Addo was then Attorney General, if not Foreign Minister. I'm missing the date. Mm-hmm. But these things happen. Nobody has ever criticized a vacation court sitting. Suddenly, the people who ordered 12 courts, High Court to sit 2 years ago or 3 years ago in this country, and he was then leader at the bar, Godfrey-Addo. Again, CJ Wood in 2011, we had commercial courts. Some commercial cases were delaying. You know, those days, Cancom and those ones. CJ Wood directed that all the commercial courts, Justice Tanko and Co., Justice Barbara Kayensu.
But that was because she had been petitioned by business community that it was going to affect, the long vacation was going to affect.
Do you know the petition before the CJ?
What made those cases special than...
Good. They were not even criminal cases.
Than someone's contracts.
Because they were commercial litigations.
Yes.
And people felt that commercial litigations, you don't have to drag it as a normal civil litigation.
I think that's the same lens we are
using.
It's
the same lens we are using for the criminal litigation. That in criminal litigation, as for the person who has stolen a fowl and is before some district court, yes, by all means, normal time can grind. But in some of these cases, it's the same MPP who are telling the government that their aura is dead. There are cases before the court. Nothing is happening. The same people.
Well, now you hit the nail on the head. They make a very important point.
But let me tell you. No, it is not.
To appeal to your base.
I've given you precedent.
Yes.
I've built my case on that precedent that every year the court sits. Last year the court
address that fundamental accusation.
Yeah, no.
That this is part of the conspiracy.
So let me tell you that one of the judges
to appeal to your base.
One of the judges sitting in the vacation courts today, one of the vacation courts today, was among those 12 who sat 2023 under Godfrey-Addo and CJ Tokonu. Kokuvite, that they are complaining today. She was a high court judge. She sat. She was given a warrant to sit over a lot of criminal matters. The same judge is sitting today among judges selected to sit. And that one, hell must break loose. So I'm saying that this is rather my seniors, that's Atachia, Dami, Samokujeto, and Obo. Obo has also petitioned.
Oh, I see.
It's all these my seniors who are playing politics with this matter. Because they have been vacation court practitioners.
Yeah, but Roxanne, address for me, are you conspiring with the Chief Justice to fast-track these cases just to prove to your rank and file that oral is working? That's the fundamental accusation.
The vacation court lasts for only 60 days. And in 60 days, the maximum court hearings you can do is about 5 in a vacation. 5 hearings. You can't finish a case in 5 hearings. So I don't even know why Senior Atachi and Co are running away from a vacation court hearing. 5. Because once you take like 15th or 17th August, the next court hearing date may be minimum 7 days interval. You are approaching the end of the month. You enter September, maybe 2 or 3 more. Suddenly it is legal year. And once it's October, the vacation judge won't sit. He's applied to the CJ to be given his special vacation. He will go on vacation till about November ending. So there's nothing really damning about a vacation here. In fact, if I were him, it helps you to speed up your matters. You clear some of the tangential matters and the interlocutory issues. But I'm saying that there's no conspiracy because it happened in cases like the quality grain, Chachuchikata, the Jachikwisin, Atuforsin. It happened in the NCA cases. It happened even before 2000. It happened to Victor Solomon. So what are you talking about?
Okay, so let me get.
So there's no conspiracy here. The people who actually directed who gave a policy position that vacation court should sit in the vacation are the people who are opposing the same policy direction or similar policy direction today.
Yeah, Roxy, let me get that. Atacha, respond to the precedents that he cited. That this isn't the first instance where a high-profile political case is being heard during the vacation.
And commercial cases.
The argument is so obnoxious, I wish I didn't respond to it at all. Because at the end of the day, Nelson, you see, granted Akufo-Addo was very wrong. 2 wrongs will not make 1 right. No. I think the principle should stick with you because of the future that I believe you have in the politics of this country. I do not see how anybody will be doing a funny post-mortem that, oh, the past was ugly, let's repeat it. Where is our growth in democracy? So I will leave it as it is. I don't have the full facts about the quality grain and all the examples that is cited, whether they were done in the vacation or not. But even if it was so, should we repeat our mess? Should we devalue ourselves because today we are doing tit for tat? Is that the argument coming from a prominent member who is at the face of the majority in parliament? I can't accept those things, But let me come to this point that they can't answer the questions in this studio. So probably we need to take it to a higher dimension and see whether when you have the powers of discretion, you can have a 2-tier, justice delivery system. One is fast track. Some cases are special, and the others do not matter at all. It's a normal track. The Supreme Court themselves should come out with a decision on this matter. Let's see how it goes. But for me, some of the things that are being said here, I can see it's just windy rhetoric, They don't address the fundamental issues that touch on the Constitution. And 2 lawyers, as I know them, prominent lawyers, should uphold the Constitution.
And Natasha, very finally, so on the 17th of August, when your client goes back before the court, he's been told what to expect. What have you told him, and what do we expect? Do you expect him seriously to cross-examine the witness?
I'll confer with him tomorrow because today has been very busy for me. And when he went to court, I'm here to confer with him. But I've told you something which is very critical. It is not right for a judge to say that I'm a vacation judge, I want to do part heads. Is being challenged, and that a carpenter should remove the tooth of a man rather than a dentist. So what are you trying to put across? That the man should go into that skilled area to cross-examine an individual. And if the cross-examination should abide term time, what is the cost to the nation? What is the emergency situation about this that lawyers can't rest and during term time, I can come and do this cross-examination? What is the hurry about? That is my concern. The hurry is an aberration and it's against the Constitution that we have to challenge. What is the hurry about?
Atacha, thank you very much. And Odamte, very quickly, justice must not only be done, it must be seen to have been done. If you think about that, isn't it in the interest of justice then for the Chief Justice to say, listen, if this goes ahead and an outcome is pronounced, it's already in the eyes of the public, one that has been premeditated, an outcome premeditated already, which is what they're selling. In that circumstance, shouldn't the Chief Justice just, listen to them and adjourn this till when they come back?
So I think that cannot be the case. It shouldn't be the case because we need to understand that there is a difference between a situation where something has happened in the past and it was wrong and people criticized it. And so when someone else is in a different position, then they should not repeat it. That should be distinguished from when we are making a claim that something cannot happen at all because of a convention over the years. I think my learned senior is now moving away from the arguments he made earlier. Initially, his argument was that...
And very brief, because I just have a few...
Yeah, was that trials have never happened during the legal vacation. But he's moved from that to now saying that if it happened in the past and it was wrong, then you can't repeat it now. No one has said that it was wrong when it happened in the past. Crimes should be prosecuted expeditedly. We should all dislike a situation where crimes are committed and we are not able to try them expeditedly through the legal system. And all over the world, there are circumstances where different issues are treated differently by courts. Even in Ghana here, our Supreme Court has situations that are brought before them that they hear expedited.
Okay.
Right? So it is possible. We are not trying to create a two-track system within the court system.
I mean, what I know is going to be interesting is what happens really on the 17th of August when they appear before the court, whether indeed Edubahen will be compelled to cross-examine. As I remember very famously, and I got an opportunity to ask him recently, he had to resort to the Bible in court to argue his case because his lawyer wasn't there. And it's good to remind us of that history. And I was in court covering that case, so when you said it, I remembered it very clearly. Look, enjoy the rest of your evening. We'll wait till 17th.
That's right. Did you see that? That is me. Without me, that tap would just be decoration.
That's so. So when the water comes, where exactly is it waiting? Pipe. I also didn't see any bedroom no. Me tank. Me na me kura.
At least I move water.
And I keep it safe.
Without me, nothing flows.
What's happening?
I bring the life.
I preserve it.
Hey, why is the water going on and off like this? Maybe I can do it alone.
Maybe I need you too.
It's true. Strong, reliable, built for every home. Syntex pipes and tanks, the perfect water team. Syntex, a year strong, a year tough.
Upgrade your print game with Konica Minolta, proudly powered by SkySat Technologies. From all-in-one machines that print, scan, and copy to professional systems and heavy-duty production machines, we deliver unmatched performance. Right now, SkySat has an unbeatable offer. 1 entire year of free servicing on all Konica Minolta machines. That's 12 months of expert maintenance for new and existing customers. Visit our new VIP Print Center at Pegasus Place, Airport Residential Area for a live demonstration. Call us on 050-164-5180 or 0302-798-829. Again, it's 050-164-5180 or 0302-798-829. SkySat Technologies. Performance that delivers every time. Misters, bad referee decisions. Don't let your child's grade suffer a bad match. Ensure a straight win this academic season with curriculum-aligned textbooks and interactive tools from Pegasus Publishing. From preschool to senior high school, we have the exact game plan your kids need to ace their classes. And because it's World Cup season, you get a massive 20% off every single book. Don't drop points. Call 059-50-10175 or dash to Pegasus Publishing in Accra, Newtown, right opposite the Total Energy Station. Free delivery within Accra when you call. Pegasus Publishing, shaping minds, winning futures.
This July, get ready for stories that will make your heart race. From love and passion to secrets and lies that can ruin everything. Catch the sizzling episodes of Sins and Roses at 4 p.m., Domenica Monteiro at 5 p.m., Be My Sunshine at 6 p.m., and Avenida Brazil at 7 p.m. Central African Time. Only on Novelas Plus, Channel 134 on GoTV.
Gold, bauxite, manganese, lithium, Ghana's minerals, and billions, and now anchor our national reserves. But in the communities that host the mines, the question is simple: what stays here? On the 18th of August 2026, that question gets answered in public.
Here in the catchment communities, this is what's really at stake. Jobs, local content, corporate social responsibility. People here want a fair share of what's mined on their land. And in the room, the conversation will be about what the large-scale mining companies are doing to better livelihoods in their catchment areas, and also the gold board reforms in the artisanal and small-scale mining sector. And finally, the signing of the catchment charter, which will put all these commitments into writing. The National Mining Dialogue 2026, rethinking the social license to operate. Regulators, large-scale mining companies, small-scale mining companies, gold buyers, traditional leaders, and host communities, all at one table.
Live from Kempinski Hotel, Accra, on Joy News, Adum TV, and Asempa FM, and all our social media handles. Chairperson for the event, Gamanche, His Royal Majesty, King Takite Kuchu II. Special guest of honor, Dr. Julius Debra, Chief of Staff to the President of the Republic of Ghana. Special guests, the Honorable Emmanuel Amakofi-Boa, Minister for Lands and Natural Resources and Member of Parliament, Elembele Constituency. The National Mining Dialogue will be held on the 18th of August 2026, 12 p.m. The National Mining Dialogue is powered by Ekusi Sen on Asempa FM in collaboration with Semis DS Group Limited, partners, the Ministry of Lands and Natural Resources, the Minerals Commission, the Ghana Medical Trust Fund, and the Ghana Gold Board.
menstrual hygiene remains a significant barrier to girls' education and well-being, particularly in some disadvantaged communities. UNESCO estimates, for example, that about 1 in 10 girls in sub-Saharan Africa misses school during menstruation. And in some areas in our own country, far too many schoolgirls are forced to use improvised and sometimes substandard materials because sanitary products are unaffordable.
Menstruation is a natural biological process, but for millions of girls in Ghana, it is not just about blood, it is about shame, fear, poverty, and missed dreams. Over the years, UNICEF Ghana, through its WASH and adolescent, gender and youth programs, has supported menstrual hygiene initiatives. Yet, according to the Ghana Statistical Service Mixed Survey, 9 out of 10 girls in Ghana miss school during menstruation due to cost, stigma, and lack of facilities. Girls often lack safe spaces, accurate information before first menstrual period, and affordable sanitary materials. Many resort to rags, toilet rolls, and papers, especially in rural areas, which sometimes lead to exploitation. In response, government allocated 292.4 million Ghana cedis in the 2025 budget for free sanitary pads in primary and secondary schools.
I promise to reintroduce the distribution of free sanitary pads to female students in primary and secondary schools. The 2025 budget statement allocated 292,400,000 Ghana cedis for this commitment, and I launched this initiative on the 24th of April 2025. Procurement is ongoing for over 6 million sanitary pads, with each student receiving 3 packets per term at the basic level and 4 packets per semester at the secondary level. Distribution will be done through the Ghana Education Service structure to all 261 districts, ensuring that no beneficiary is left out.
Girls are still missing school during their periods. For many, the reasons are painfully simple: no pads, no privacy, no water, but overwhelming shame. In the Ashanti region, I met Amina, a head porter at the bustling Edum Central Business District. Her job is tedious, but she keeps moving. Each trip means a little more money for survival. She is a mother of 3, 1 boy and 2 teenage girls who have started menstruating. Amina says she's unable to afford sanitary pads for herself and her 2 daughters because the price is too high for her.
If your menses come, sometimes you can carry the distance, the pine, and what am I going to say? Like you want to find 1 cedi or 2 cedi and buy something to eat, you won't get that money. So if you didn't get that money and you are, but you can't find money to buy this thing, pad.
Sanitary pad.
So it's difficult for us.
So when you don't get the money to buy the sanitary pads, what do? You
can take this thing, T road or this thing, what am I going to
Papers?
The paper or this thing, rag. So all that is infection for us.
Amina recalls a painful moment when menstruating while carrying a heavy load with no access to proper materials or a place to clean up.
say aya ye bi mo nim ye days enti unimu dey a.
If you come to work, there is no money to eat, and if you menstruate, you can't find money to buy pad. Sometimes you carry the pan